Welcome to Justice Trial Nexus.
This episode departs from our usual format to highlight 3 memorable moments in which judges reprimanded attorneys appearing before them. Our first admonishment took place in the 215th Judicial District Court in Houston, Texas. On June 23, 2025, plaintiff Lawrence Kuykendall filed a civil suit against defendant Turner Jones. The case was presided over by Judge Nathan Milliron, and Mr. Kuykendall was represented by attorney Eric Rhodes. On January 28, 2026, Mr. Rhodes filed an application for temporary injunction and temporary restraining order seeking to halt an auction for the issuance of 1 million additional shares of the parties' jointly owned business. The court granted the temporary restraining order that same day, and on February 13th denied the application for temporary injunction. On the morning of February 17th, Mr. Rhodes failed to appear at a hearing, then approached the clerk later that afternoon requesting an emergency hearing to stop the sale of stock. The court set the matter for an in-person emergency status conference on February 18th at 8 a.m.
Mr. Rhodes, tell me why we're here today. You asked for an emergency hearing from my clerk yesterday verbally.
Yes, Your Honor. Well, we're here today, Your Honor, because the court set the emergency hearing for.
Because you requested one, sir.
Your Honor, what happened was...
You didn't appear at my hearing yesterday again.
If I may respond, Your Honor?
Please, I'm waiting.
So, Your Honor, as it relates to yesterday, in non-appearance for yesterday, the short answer is that it was not on my calendar.
Were any of the other 6 hearings you didn't attend on your calendar?
Your Honor, I don't believe it was 6 hearings that I missed.
Do you want to go through the record again?
No, Your Honor. But Your Honor, what happened on yesterday as it relates for a hearing, as the court is fully aware, there was a TI hearing in which was denied regarding the sale of the stock.
And you're getting ready to go back to the ancillary and try to overturn me again, right?
No, I'm not going to do that, Your Honor.
I assure you, you're not.
Okay, so what happened, Your Honor, there's been communications between me and opposing counsel, in particular, going back and forth and trying to get the matter resolved as the case would be. It wasn't until late yesterday, Your Honor, not to violate attorney-client privilege communication, it wasn't until late yesterday that I was directed to seek, if it was possible, to go and see if we could have it modified. At that moment...
Why would I modify it after you've had 6 weeks to modify it?
Your Honor, I was instructed to do it by my client.
Where's your client?
My client...
I instructed him to be here today. Where is he?
Okay. I have no...
I'm about to issue a bench warrant. Where is he?
Your Honor, I have no idea where my client is at
Okay.
this moment. But Your Honor, may I explain?
You may not. I'm asking where your client is. You don't know.
Your Honor, if I may explain. When I called, the court advised that we had an emergency hearing scheduled for this morning.
At your request.
I advised my client of the emergency hearing on a status conference. The emergency hearing on a status conference.
That he was ordered to appear at.
Your Honor, I didn't. By the time I got the order, I was driving while I was speaking with...
I understand. You did it late in the day, and I did it late in the day.
By the time I got the order and tried to reach out to him, I could not reach out to him. I could not contact him.
Why don't you contact him right now and see where he is?
If I may, Your Honor?
Yeah, absolutely. We'll do it on the record. I'd like an address where he is because I'm about to send out the constable.
This is probably the 10th phone call that I've made.
Please record your
And
message.
this is what I get. I've sent an email. I've sent text messages.
When did you send the last email to him?
Last email was sent to him probably at about 5 o'clock this morning.
Why don't you show me that email? Mr. Rhodes, frankly, I don't believe a word you're telling this court at this point. Deputy, find out who's in my ready room, please.
Actually, by way of correction, Your Honor, the last email sent out was at 7:24 a.m. this morning.
Okay. And your client doesn't want to respond to this case? Does your client want to prosecute this case anymore, or should I dismiss it?
No, yes, he does, Your Honor. He does want to prosecute the matter, Your Honor.
Where is he?
I have no idea where he is.
Go find him right now.
May I be excused?
Yes? Bill, can step back.
All right.
Mr. Rhodes, any luck?
No, Your Honor. No luck in contacting him. Mr. Simpson, Attorney Simpson, was able to contact the daughter, who advised that he was in Port Arthur, and also provided me with another number. I tried contacting that number multiple times, and it just goes straight to, actually, not even voicemail, says that it's full. So.
It's clear to me your client doesn't want to prosecute this case. Why didn't you appear for 6 weeks? And then you appeared last week on Friday. You didn't appear yesterday, and now again this morning, you're requesting emergency relief from this court.
Actually, Your Honor, as I mentioned earlier, I did not appear yesterday because the hearing was not on my calendar. When, as directed by my client to see if there was availability to have an emergency hearing, not today, but later next week.
Well, you're not getting anything later next week. I promise you that.
I completely understand, Your Honor. I was advised that they wanted to have the hearing this morning, and I advised the court that we were not seeking a hearing to seek relief for today.
Well, but that was after you requested relief from my clerk, and she reached out to me late yesterday afternoon. Tell me what I do to make this right for everybody else in this courtroom that has spent their time and money this morning.
I don't have any suggestions, Your Honor.
All right. Well, I do. You're going to pay sanctions in the amount of $5,000. Get out of my courtroom now. And those sanctions are payable by you directly, not your client. I will sanction him directly in the future. Get out of my courtroom. Y'all are excused. Y'all on the 8:30 docket, have a seat, relax. Find me a bench warrant. I want him arrested. Find me a bench warrant. I want him arrested.
Judge Milliron orders Mr. Rhodes to personally pay $5,000 in sanctions, specifying that the amount is not to be paid by his client, and directs the issuance of a bench warrant for Mr. Kuykendall's arrest. As the Court of Appeals of Texas explained in the 1992 case of Kutch v. Del Mar College, Texas courts have the inherent power to impose sanctions for conduct affecting core functions of the judiciary. The Supreme Court of Texas determined in the 1998 case of In re Bennett that this inherent power includes the authority to discipline an attorney's behavior through sanctions instituted on a court's own motion. Whether a particular sanction is quote-unquote just is governed by the 1991 case of Trans-American Natural Gas Corp. v. Powell, where the Supreme Court of Texas held that constitutional due process requires that any sanction imposed not be excessive. Well, under this standard, the reasons supporting the sanction, including Mr. Rhodes' non-appearance at properly noticed hearings, must be weighed against his due process rights for the sanction to pass constitutional muster. Our next courtroom reprimand occurred during the high-profile Parkland school shooting case. On February 14, 2018, a former student opened fire at Marjorie Stoneman Douglas High School in Parkland, Florida, killing 17 students and staff members. Following his guilty plea, defendant Nicholas Cruz proceeded to a penalty phase trial in Broward County before Judge Elizabeth Scherer, which concluded on October 13, 2022, when the jury could not unanimously agree on a death sentence, leaving life in prison without parole as the only available outcome. On November 1, 2022, the court held the first day of a 2-day sentencing hearing, during which the families of the victims were permitted to address the defendant directly. After one witness commented that the defense attorneys would have difficulty facing their own children after representing Mr. Cruz, the defense team raised the issue with Judge Scherer, arguing that references to their children were improper and should be out of bounds.
No one jumped up to try to tap down that rhetoric. That is the rhetoric that I'm talking about. That is what I'm trying to be very clear on. Jeff Marcus, the state, they can hide behind their arguments, but we all are witnessing what is occurring in this courtroom.
Which is myself. I'm a judge, and
I
I understand that I'm in
Thank you,
charge
Judge.
of the decorum, and I feel that 99% or a great percentage of what has been said has been appropriate. Everybody has maintained decorum, but for a few comments, it's best to just move on as opposed to highlight them.
This is true, Judge, but I am witnessing a building of momentum, and I'm encouraging the court to direct the state to tap down on that momentum so it does not reoccur and it does not become a theme. Thank you, Judge.
Your Honor, for the record, the only thing the state has said to any of these witnesses when they get up is, would they like to say something on behalf of the victim they're representing? There's been no encouraging or inciting, as Mr. Weeks has put on this record. That is a blatant falsehood and a recreation of the records. As far as no objections being made, it's the defense that could have objected. It's not the state's duty to object to their own witnesses when they're testifying.
Okay. Listen, I've already heard. If you have anything else to say, you can put it in writing at a later time. I've heard from both sides more than once. That's going to be it. I've made my decision. Like I said, 99% of what's been testified to has been appropriate. I do not want to highlight the few things that were said that were perhaps not appropriate, and let's move on.
Judge, I'm asking for 20 seconds next.
You can have as many seconds as you want in writing, and you can put all of your objections in writing. They've been made multiple times from your chief assistant, from Ms. McNeil, and I don't want to hear anything else. I've already heard it. Is there something that has not already been argued?
Yes, ma'am.
Okay, exactly what is it?
Judge, before Mr. Schachter took the podium and testified before this court, I wanted to the record to reflect that both Mr. Marcus and Mr. Sass looked at the statement prior to the briefing. And so their implicit adoption of what he was saying, of his improper arguments, supporting the court should.
Okay, but what you are doing right now is highlighting something and making more of a spectacle. So if your office in general does not want to facilitate and or incite violence, then we need to just sit down and move on. That's it. There were 18 witnesses, 16 or 18 witnesses that testified today. There was nothing that was said until Ms. McNeil made her point made, and, you know, we're moving on.
But is the court going to do anything about maybe stopping it from happening again?
When these people are upset about specific things that have gone on from that table, like shooting the middle finger up at this court and laughing and joking, Ms. McNeil, be quiet. When these people have sat in this courtroom and watched this behavior from that table, and they want to say that they're not happy about it, what is the problem?
Judge, I have no problem because I have thick skin. But once you bring in my children, I think that's highly improper. I
didn't even know you have children. I don't know what you're talking about. Your children? What about your children?
But then the comment on my children is highly improper. Before this court to allow that kind of testimony is also improper.
There was, I don't remember any comments about any children. And if there was, it obviously didn't, it came and went without me noticing it.
Judge, I can assure you that if they were talking about your children, you would definitely notice it.
You need to sit down right now. You're out of line. In fact, you're excused. You need to go sit in the back with your chief public defender.
He's the public defender.
Mr. Weeks, please ask the lawyer from your office to go sit down and not say anything else. To try to threaten my children and bring up my children is inappropriate. Go to the back of the room now. That just violated about every rule of professional responsibility that I have never. If you're going to get up here and you're going to...
Judge, I asked you to go sidebar on this matter.
You, sidebar or not, you don't have one of your assistant public defenders say something about my children?
Judge, that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning when their children
She brought up her children multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children.
Judge.
Sit down. Sit down.
Judge.
Sit down, Mr. Weeks.
Please do not summarily dismiss me.
I'm summarily dismissing
I'm asking
you.
the
Go
court.
sit down.
I'm asking the court. I asked the court to go sidebar.
Go sit down. You don't threaten the
Judge,
Court's children.
everyone
Your
in this
assistant just did
courtroom-
that. Go sit down.
No one in this courtroom had to endure what we have to
Go
endure.
sit down. Miss McNeil has made her children a spectacle more than once during this trial. That was her choice. You have absolutely no right to have one of your assistants come up here and suggest something about my children. Now, please go sit down.
Judge.
You're inappropriate and out of line. Go sit down.
Judge, may I have a brief recess?
No. Go sit down.
May I have a brief recess so I can speak to my attorneys?
We're moving on with the sentencing, Mr. Weeks.
Can I have a brief recess?
No.
Thank you.
It's 1:36. Thank you. State, go ahead and call your next witness.
Mr. Anthony Montalto.
Judge Scherer rejects the defense team's objection, and following an exchange in which defense attorney David Wheeler referenced the judge's own children while pressing the argument, directs him to be excused from the defense table and sent to the back of the courtroom. Florida jurisprudence has consistently recognized that courts possess inherent authority to manage the proceedings before them. In the 1978 case of Rose v. Palm Beach County, the Florida Supreme Court explained that courts have the inherent power to do all things that are reasonably necessary necessary to administer justice within the scope of their jurisdiction, subject to existing laws and constitutional provisions. And in the 1952 case of Petition of Florida Bar, the court described that inherent power as extending to the incidents of litigation, control of the court's process and procedure, control of the conduct of its officers, and the preservation of order and decorum with reference to its proceedings. Now, as to the underlying objection that prompted the exchange, the scope of what victims may say at sentencing is governed by Section 921.143 of the Florida statutes, which provides that statements by victims and next of kin shall relate to the facts of the case and the extent of any harm, including social, psychological, or physical harm, financial losses, loss of earnings directly or indirectly resulting from the crime, and any matter relevant to an appropriate disposition and sentence. This statutory framework is reinforced by Article 1, Section 16 of the Florida Constitution, commonly known as Marsy's Law, which guarantees crime victims the right to be heard in any public proceeding involving sentencing. Neither Section 921.143 nor Marsy's Law expressly addresses statements directed at defense counsel or their families. And here, the defense's objection rested on the position that such references fell outside the scope of permissible victim impact testimony. Now, our third and final rebuke comes from the 14A District Court in Washtenaw County, Michigan. On October 30th, 2025, defendant Samuel Peoples appeared before Judge J. Cedric Simpson in a pending felony case to address a request for a competency evaluation and a bond violation arising from his tampering with the electric monitoring tether that he had been released on. Mr. Peoples was represented by the Public Defender's Office, with Assistant Prosecuting Attorney Rachel McDuffie appearing for the state.
Court does call the cases of the people versus Samuel Peoples.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, Mr. Peoples has not yet been referred to the Forensic Center. I've prepared an order, and we are asking the court to order a forensic examination of that case.
I will order a forensic examination without objection.
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in felony case 1326. Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category this was in.
Yeah, this is wrong. Okay. All right.
We would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. Between now and October 30th, we are hoping to file a written motion, I think something substantive that gives the court a better idea.
What's the objection in releasing? The thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I thought exciting.
Response?
Your Honor, obviously we had an extended conversation about this at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're going to cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Well, you understood it before, you just did it.
I had a moment of anxiety that led to a freak out, and I felt like I needed to get it off me because it was claustrophobic. And
Got it.
yes,
I hear you. It's going to be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap.
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
yes, Your Honor.
I give you another shot. You're going to try to do the right thing?
Yes,
Okay.
thank you, Your Honor.
All right. I'm going to do it. I think you can do it.
Me too.
Okay.
Understand.
I'm going to reinstate your previous bond where you were previously at home, right?
Mm-hmm.
They'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right, thank you, Your Honor.
Okay. Don't let me down.
Yes, sir. Your Honor, may I add one thing? After consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor without necessarily violating a confinement order.
Response?
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, so that the court would be apprised of what was happening. But the tether conditions ought to remain the same.
Actually, what happened last time was the public defender came up on Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Yates, right now.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do, and I made it very clear, we'll bring him in here. Because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. Their request for a tracking tether change.
Stop talking. You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
All rise. CJ District, County of Washington, State of Michigan, is now back in session.
You may be seated. Peoples.
Radman is joining me right now.
Your Honor, I'm very familiar with Mr. Peoples' case that the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case so that he can be released, because otherwise he would be held on that. He'll be refitted with a GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid and all prior conditions are reinstated. And then we need a new date. It's actually going to be October 30th.
Okay.
It's going to be our date. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
Okay. Okay. Thank you.
Following the dispute between Ms. McDuffie and Judge Simpson over what had been said at a prior hearing, Judge Simpson orders counsel for both the defense and state to meet with him in chambers. When the parties return, a different assistant prosecutor appears in place of Ms. McDuffie to finish the hearing. The decision to move a dispute into chambers is a tool available to a trial judge to address attorney conduct without escalating the issue in open court, and it allows the judge to manage tension between counsel and the bench while preserving the dignity of the proceedings. However, Canon 3A5 of the Michigan Code of Judicial Conduct prohibits a judge from initiating, permitting, or considering ex parte communications concerning a pending or impending proceeding, meaning that a judge cannot meet with one party or one party's attorney about the substance of a case without the other side being present. By bringing both the prosecution and the defense back to chambers together, Judge Simpson addressed the dispute with Ms. McDuffie outside of open court while keeping both sides in the room, which preserved the ability to manage the conflict privately without running afoul of the prohibition on improper ex parte communications. These 3 courtroom proceedings, though arising in vastly different procedural contexts, illustrate a single foundational principle. The courtroom is the judge's domain, and the authority a judge holds over the proceedings before them is broad. When an attorney believes a judge has gotten it wrong, whether on a sanctions ruling, the scope of permissible testimony, or the management of in-court conduct, the available avenues for challenge are narrow and structured. An attorney may make a record by stating an objection, may move for reconsideration through proper procedures, and may sometimes pursue appellate review of rulings that they believe were erroneous. What an attorney cannot do is press the disagreement in the moment by escalating the confrontation, raising the stakes with personal references to the judge, or insisting on the disagreement after the judge has signaled that the conversation is over. The consequences of that kind of mistake can be significant and immediate. A $5,000 sanction payable from the attorney's own pocket, removal from the counsel table in front of the jury, or a judicial reprimand, they can impact both the attorney's career and the outcome of the case. Judges are not always right, and the appellate courts exist precisely because trial judges make mistakes. But the courtroom is rarely the forum in which to win that argument. An attorney's most effective tools for challenging a judge are the record, the motion, and the appeal. And trying anything else, however justified the underlying frustration may feel, that tends to produce outcomes that serve neither the attorney nor the client. Let us know if there is a case or courtroom interaction that you would like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.